All right, we're at 6 o'clock, so we're going to get started. Hello, everyone. Thank you for joining the Whitkin State Law Library, part of the California State Library, for a special program on environmental law and the things we need to build with Professor Dave Owen of UC Law San Francisco. My name is Elena Smith, and I'm the host of tonight's event. I'm a reference and outreach librarian with the Whitkin State Law Library of the California State Library. We also have a co-host tonight, Mona Robinson, who is a supervising librarian for our law and government publications sections. Mona will be monitoring our Q&A throughout the talk for any questions you may have for Professor Owen, and she will read your questions during our Q&A session at the end of the presentation. This program would not be possible without the support of the California State Library Foundation, for whom we are eternally grateful. To learn more about the foundation, you can visit their website at cslfdn.org. Before I go any farther into our program introduction, I also want to acknowledge that I work on the unceded ancestral homeland of the Nisenan and Miwok peoples, many of whom continue to live and work here today. As such, I am a guest on this land, and I want to acknowledge, thank, and honor my hosts. The California State Library is thrilled to have Professor Dave Owen of UC Law San Francisco here to discuss aspects of the debate over whether environmental law is keeping us from building important things, such as housing, and from building things that would be good for the environment, such as renewable energy. It promises to be an exciting and interesting talk. To make sure that you have the best experience possible, I'm going to go over a few housekeeping details, and then we will get into the presentation. We just switched slides here. Okay. If you have any questions during the presentation, please type them into the Q&A section and we will answer them at the end of the program during our Q&A session. This presentation is being recorded and made available after the talk. Live transcription is enabled, so if you'd like to see captions, click the CC icon to show subtitles. If you run into any technical difficulties during the presentation, please put those in the Q&A section, and we will try to help you if we can. We've added links to the California State Library and Professor Owen in the chat window. For any state employees without a library card, please consider applying for one through the posted online application link, and don't forget to register for one of the State Library's many other speaker programs. All right. Oh, hold on one second here. Okay, and now I'd like to welcome Professor Dave Owen. Professor Owen teaches courses in environmental law, water, land use, energy, and administrative law at UC Law San Francisco, where he is also the Associate Dean for Research. He went to Berkeley Law, where he served as editor-in-chief of Ecology Law Quarterly, and then clerked and practiced water law. In 2007, he began teaching at the University of Maine. He joined UC Law faculty in 2015. His research focuses primarily on water resource management, and recent projects have addressed water district governance, environmental negotiations, takings litigation, groundwater surface water interactions, the environmental consulting industry, the role of federal regional offices, stream protection under the Clean Water Act, and policies to expedite dam removals and hydropower upgrades. Several of his articles have been recognized as among the top environmental law articles of their years, and he has won UC Law's highest award for teaching. Please join me in welcoming Professor Dave Owen.
So thank you, Elena, for that introduction. Thank you to the California State Library for inviting me to give this talk. And thank you to all of you for being here. Give me just a second. I will share my screen and then get started. Okay, so the talk I'm giving tonight, as Elena said, is about whether environmental law is getting in the way of building things that we need and things that are particularly good for the environment. This is very much a hot topic lately, and my hope is to give you just some useful information about where this debate is coming from and how accurate these claims are. So here's a quick overview of what I will talk about. So first off, why are people saying that there are these conflicts between environmental law and infrastructure that is environmentally beneficial? Second, what do research data from academic and other studies tell us about these conflicts? How real are they? How extensive are they? Third, I'll talk about what lawmakers and government agencies are doing and have been doing to address these conflicts where they do come up. And I'll finally also talk about what else we could do. I'll also start by giving you a few of the key conclusions of this talk that I'm going to explain in more detail in the time to come. So first, there are conflicts between environmental laws and the construction of environmentally beneficial infrastructure. But particularly in popular media accounts, the extent of these conflicts is routinely and significantly overstated. Second, legislators and regulators are taking steps to address these conflicts where they do arise, and in fact, they have been doing so, and often doing so effectively, for many decades. Third, there's always room for improvement, more reforms are possible. Fourth, focusing on environmental law as the key to getting housing built or to getting renewable infrastructure built probably isn't our high or shouldn't be our highest priority. There are other things that we can do that will likely matter more. And then finally, and this is a broader point, with this issue or with anything about environmental law, I think it's important to be careful about making too much of the sort of anecdotal evidence that we routinely hear in popular media accounts. Often those eye-catching stories are outliers. And if we treat them as representative of the way environmental law usually works, we'll really misunderstand the field. So to put this all in context, I'm going to start by giving a little bit of history and a little bit of history of environmental law to explain where some of these current conflicts are coming from. This is going to be a little bit of a whirlwind tour, so I'll go fast. So we often think of environmental law as representing the confluence of two different movements. One is the preservation movement that was spearheaded by people like John Muir, who you see on the right here. And that was carried forward throughout much of the 20th century, led by people like David Brower, who you see here trying successfully to save Grand Canyon. And then that movement had a confluence with a public health movement that was more focused on things like toxins and pesticides and pollution. And they came together, partly spurred by some spectacularly bad environmental events, like the ones that you see here, to form in the 1960s what we now think of as the modern environmental movement. And that coalesced around events like Earth Day, and it led to the passage of lots and lots of laws. So here you see Richard Nixon signing into law the Clean Air Act, one of many laws that he signed during this period. And here's a quick list of some of the major federal laws that were passed from the very late 1960s through the 1970s, and that really gave us much of federal environmental law as we know it today. It wasn't just the feds. States also got in on the act of creating environmental law. So here you see Ronald Reagan signing into law the California Environmental Equality Act, about which we will hear more later in the talk. And these laws were interesting and distinctive in a lot of ways, one of which was their emphasis on litigation. So here you see some of the text of the citizen suit provision of the Clean Water Act, one of the major statutes of this period. And the key point here is that the legislators who created these laws wanted government agencies to implement the laws, but they didn't trust them to always do that on their own. They worried that industry might have too much influence or that politics would get in the way. And so often they empowered members of the public to sue, to either sue polluters directly or to sue to force government agencies to act. And this provision, and many others like it, gave us a system of environmental law that we often think of in this sort of simplified way. We often think of environmental law in the United States as being highly prescriptive, filled with rigid and detailed mandates. We think of it as demanding, as setting really tough standards. And we also tend to think of it as litigious. The idea is that there's lots and lots of lawsuits around environmental law. And I should say that this is a description that in different ways works for a lot of people involved in the environmental law field. If you're an environmental group, this helps you fundraise. If you're a corporate defense attorney, this helps you scare your clients and justify your $1,000 an hour bills. If you are a conservative activist who wants to raise fears about environmental law, again, this is a pretty compelling story to tell. And then, of course, if you're a law student who wants to change the world through your briefs and through your oral arguments, well, this story lets you think maybe you can do that. And so it's become a very compelling and very durable narrative. As I'll explain going forward, I think there's also a lot that it misses. So even a brief history of environmental law wouldn't be complete without talking a little bit about successes and failures and emerging challenges. And let's start with the successes. And the key point here is that in some ways, environmental law has been incredibly effective. Here you see one example. These are levels of major air pollutants over time. And what you can see here is that the trend is towards declining levels of air pollution for a whole host of major and important pollutants. And this is happening in spite of the economy growing massively over the same period, in spite of our population growing, vehicle miles traveled growing. And so because of the Clean Air Act, which is just the example here, our levels of pollution that we face in our society are far less than they otherwise would be. That has saved thousands and thousands of lives. It has saved billions of dollars. And it's not just air quality. That's the Cuyahoga River. You saw it burning a couple slides earlier. This is what it's like now. And it's one of many rivers where water quality is far better than it was before the advent of environmental law. And we also have cleaned up thousands and thousands of hazardous waste sites. We also aren't creating them at anywhere near the rate that we once did. So here you see a restored hazardous waste site in Milwaukee, just one of many examples around the country. And I could go on, but the basic point is that in a lot of ways, environmental law has thrived. It's been highly successful. But there have also been significant challenges which are ongoing. Environmental justice, which is concerned with equity, which is concerned with the burdens borne by people of color and poorer people, remains an enormous issue and one that we're making progress on, but in many ways we have not solved. And of course, the biggest challenge and a motivator in some ways for this talk is climate change. Here as well, we are making progress, particularly in the state of California. We are moving towards more renewable energy. But as we'll see in a few slides, we have a long, long way to go. And I don't think anyone would pretend that this is an issue that we have successfully addressed. So throughout the time that environmental law has operated, there have been critiques. And the traditional critiques largely came from regulated industries, and they largely alleged that environmental law just went too far, that it was too single-minded in its pursuit of environmental goals, and that it did pursue those goals at too much of a cost to the economy. But particularly in recent years, a different sort of critique has risen to prominence. And you can see a few different examples of it here. In each of these quotes, what the critics are saying is that environmental law is really getting in the way of environmental protection, and that it is doing this because it is so procedurally complicated, so litigious, and also so biased toward the status quo. And note where these quotes are coming from. The Atlantic, the New York Times, the New Yorker. The Washington Post quotes didn't quite make the cut for this slide because I didn't want too much text on it, but the same narrative is there. So these are really bastions of the liberal, or at least the center-left establishment, that have decided that something is terribly wrong with environmental law and that it is suddenly getting in the way of the goals that it purports to try to achieve. It isn't just popular press writers. A similar narrative has emerged in academic writing. The two articles you see here are two examples of it. And I should say, I think both of these articles are much more nuanced than the popular press accounts. But the basic point they are making is the same, that environmental law's emphasis on procedure and litigation and its preference for the status quo has become a danger to our ability to respond to important societal challenges. And of course, this isn't just federal law. This is also a very familiar narrative here in California, and it has been particularly prominent with respect to the California Environmental Quality Act and the construction of housing. So the question I wanted to ask or address here is, how real are these conflicts? Or what do we know? What does research done by environmental law professors and others who are trying to gather broad data sets rather than just looking at spectacular and catchy stories? What can it tell us? And I'm going to focus on two areas. First, I'm going to talk about federal environmental law and renewable energy infrastructure. And then I'll talk about CEQA, the California Environmental Quality Act, and housing. So if we're talking about federal environmental law and renewable energy infrastructure, it's important to start by understanding the motivations for this debate. And the core motivation is climate change. We have a massive, I think many of us would say, an existential crisis that desperately requires a response, and it requires a response fast. And the most important part of that response is going to be reducing the amount of energy that we get from fossil fuels, drastically reducing, even eliminating that source or close to eliminating it if we can. And what you can see here from this chart is that in the United States, we have a very long way to go if we want to achieve our climate goals for our own energy production. Of course, what happens in the rest of the world matters too, but for now, I'm just going to focus on what happens domestically. You can see from this chart that most of our energy in our society still comes from fossil fuels, and that's by a huge margin. And in order to change, what we really are mostly going to need to do is build a lot of wind power and a lot of solar power. Those right now are the most promising alternative sources of energy that are fossil fuel free. And the amounts that we probably need to build are staggering. So this chart on the left shows energy infrastructure or energy generation, electricity generation construction over the past. And then on the right, using the same time scale, you see the projected amounts that we would need to build to achieve some of our goals for effective climate change response. And so what you are looking at is an extraordinary build-out, a massive build-out of renewable energy infrastructure. And interestingly, price isn't such an object anymore. It still matters, but the cost of wind and solar is now cheaper than the cost of fossil fuel-fired energy. And so it's more than cost competitive. It actually has cost advantages. Now, if you add batteries into the mix, which we need to do in order to balance out the intermittency of wind and solar, then those costs go up somewhat, but there are still huge cost advantages, and battery costs are on a long-term downward trend. So the problem is not so much that it's too expensive to build this stuff. And so people have started thinking, well, maybe it's something else. Maybe the problem is environmental law. There's another piece to this challenge as well, and that's the issue of transmission. So on these maps, you can see where the good areas in this country are to generate wind power, and they are in the high plains and then offshore, and then also to generate solar power. Solar panels are now cheap enough that almost anywhere is a good place to generate solar power, but the particularly good areas are in the Southwest. The challenge this creates for us is that these aren't the places where we are used to generating electricity. And in order to make our national grid system work with these new generation sources, we probably need to build a lot of this. We need more transmission lines. And these are big, not particularly attractive features that cover much of the landscape. One thing to be aware of as we're talking about wind and solar and transmission is that the aggregate footprint of these types of energy generation and transmission is much, much less than the aggregate footprint for fossil fuels, and much less than the footprint for doing things like growing corn for ethanol. So comparatively, we're not talking about huge areas of land, but that doesn't feel that way if you're the one who's going to live next to it. So, okay, so when people say that law, and particularly environmental law, is getting in the way of this, well, what laws are they talking about and what do they require? And then the next thing I'm going to talk about is what effects they are actually having and what we know and what we don't know. So for federal environmental laws, I'm going to focus on three of the most important laws. The National Environmental Policy Act, which requires analysis of the environmental consequences of projects before they're built. Clean Water Act, Section 404, which requires permits for depositing dredged or fill material in waters of the United States, and then the Endangered Species Act, which is somewhat self-explanatory. These are not the only important laws. I've put some other potentially important ones down at the bottom, but in the interest of time, I'm really going to focus on three of the most important. And I'm going to start with NEPA. And here you see a quote that really captures a lot of the recent narrative about NEPA, with people alleging that NEPA in particular is a huge problem for a renewable energy build-out. And to understand why that is, it helps to understand what the law actually requires. So here I've pasted some of the key text. I know that's way too much to read on a PowerPoint slide, so I put the summary version here down at the bottom. Basically, EIS tells the federal government, tells federal agencies that they have to prepare environmental impact statements before taking actions that could significantly impact the human environment. And more specifically, the agencies have to prepare draft environmental impact statements, put those statements out for public review and comment, respond to the comments, finalize the statement, and then make their decision. And to understand the pushback or the frustrations with NEPA, the most important thing to understand is how big and complicated an EIS typically is. So here you see some statistics from the Council on Environmental Quality, which is the White House office, on the length of EISs. And the basic point here is that these typically are enormous documents. They take huge teams of people to prepare, and they take a long time, typically measured in multiple years, to go through an entire NEPA process. Now, of course, it might not be years just because of the NEPA process. There are a lot of other things that can slow a project down. But from the initiation of the project to an actual decision and a record of decision, that can be a several-year process. Then behind that, there's the threat of litigation. And so here you have a recent quote from a guest, author Jerusalem Demsas, who's on the Ezra Klein show, where she's basically saying, look, it's not just the process is complicated, it's just that anybody can sue and stop anything. And so there's the threat of litigation backstopping these intense procedural requirements. Okay, so now I'm going to talk a little bit about how things actually work and what we know about the actual NEPA process. And the most important thing to understand about NEPA is that there are a lot of ways to get through a NEPA process without preparing an EIS. And so here on the left side of this chart, I've listed different ways of complying with NEPA. And on the right, the situations where those alternative ways of complying with NEPA are allowed. And generally speaking, the further down on the chart you get, the less procedurally complex the process is. And to step back a bit, this is typical of environmental law. We're going to see this same theme with all of the laws that I talk about, and we could see it with many others that I won't talk about, where we try to tailor the level of procedural complexity to the level of impacts that projects have. So high impact actions tend to have more intense procedural requirements. Actions that are relatively low impact or below regulatory thresholds might have either relatively streamlined processes or no process at all. And so then you might wonder, well, how do projects actually typically move through a NEPA process? And I'll start by giving you some aggregate statistics here. And the statistics on the top are from a report from about 10 years ago. And it documents that this Council on Environmental Quality is estimating that about 95% of projects go through on categorical exclusions, which is basically the most streamlined form of NEPA compliance, short of no process at all. Most of the rest go through on environmental assessments and findings of no significant impact, and that less than 1% get the full EIS treatment. And it turns out that those numbers also have been declining, and declining dramatically over the years. So in the bottom, I've summarized some statistics from a paper by David Owen, who's a professor at the University of Texas, who you're going to hear a lot from in the next part of this talk. And in David's recent paper, he found that the number of EISs per year had gone from over 1,000 in the 1970s to under 100 today. So that means there's an overall shift throughout NEPA compliance towards more streamlined pathways. Now, as we talk about NEPA compliance, it's important to keep in mind that the statistics I've just given you, and most general statistics, are for all categories of projects, not just for renewable energy projects. And here you get a sense of that. You can see that renewable energy projects are just a very small part of this pie chart, that most NEPA projects are not energy projects at all, and most NEPA projects that are energy projects are fossil fuel energy. So if we want to get a sense of who really is behind the push for reduced NEPA obligations and who benefits most from that, it's not primarily renewable energy. It's coming from other sources. All right, now what about renewable energy specifically? And so here we're back to statistics from David Owen, who spent a lot of work compiling statistics over a 12-year period for how utility scale, so big, utility scale renewable projects move through NEPA compliance and through other forms of environmental law compliance. And the key point here is, first, he found that there were a lot of projects moving through the system. Not as many as we need, but definitely enough for us to get a pretty good sense of how the process typically works. And he also found that of all of those projects, only about 3% were getting EISs. So almost everything else was going through unstreamlined forms of NEPA compliance. Okay, so what about litigation, you might ask? Well, here we've got statistics from a different paper by David Adelman, this one with Rob Glicksman, who's a professor at George Washington University. And they were looking at NEPA compliance more generally on this paper, not specifically at renewable energy. And what they found here, and you can see it in these quotes, is that only a very tiny fraction of the agency actions that are subject to NEPA gets challenged in court. It's really a very tiny percentage. And a last thing that's important to keep in mind with NEPA litigation is that it, in fact, does not just automatically stop projects. Sometimes for press accounts, you think, oh, you just have to sue and then the project is stopped. It doesn't work that way. Instead, in order to stop a project under NEPA, a plaintiff has to obtain a temporary restraining order or an injunction. And that is hard to do. And I know this because I've tried, because courts review agencies' NEPA compliance under very deferential standards. As long as the agency takes a reasonable position and provides a reasonable explanation for it, it wins. And so Adelman and Glicksman in their study found that plaintiffs were only winning about a third of their NEPA cases. And most likely, most of those cases that plaintiffs were winning, they were winning because they had really good arguments. They were winning because there was something about that NEPA study that was really sweeping important issues under the rug. Short of that, it's very hard to win a NEPA case. Okay, so maybe it's not NEPA. Maybe the basic claim is right, that federal environmental law is a huge impediment, but it's a different sort of federal environmental law. And so one other potential candidate might be Clean Water Act Section 404. And if you read some of the things the United States Supreme Court has written about Section 404 over the last 20 years, you would think that this is, not just shutting down renewable energy infrastructure, but on the verge of shutting down our entire economy. Well, let's start by talking about what Section 404 actually requires. And the actual requirement is that anybody who wants to deposit dredged or fill material in waters of the United States must obtain a permit from the Army Corps of Engineers. And in order to get that permit, the Army Corps typically requires you to avoid impacting waters of the United States to the extent feasible, to minimize those impacts that you can avoid, and then sometimes to compensate for the impacts that remain by paying for wetland protection or restoration in some other location. With Section 404, we also have a system of tiered compliance processes. And this is very important to understand how the law works in practice. The most expensive and time-consuming way to move through compliance with a statute is to get an individual permit, a permit that is tailored to your project. As you can see here, that's relatively expensive. And it can take a long time, especially when you consider that the numbers I'm showing here are just after the permit application is submitted. It also takes time to prepare that permit application. The other main pathways through are to get what's known as a general permit, which is a standardized cookie cutter permit that you just opt into. And as you can see here, that's much cheaper and that's much faster. And then, of course, if you can avoid having any impact on waters of the United States, you're not filling them at all, then you don't need a Section 404 permit. You can bypass this process entirely. Section 404 is important for another reason, and that's that the discretionary decision that agencies make when they're doing Section 404, that the Corps makes when it's doing Section 404 permitting, often is also the trigger that leads to NEPA review, and then often is also a trigger that leads to compliance processes under the Endangered Species Act. So Section 404 has a sort of regulatory multiplier effect where it applies. Another important thing to know about Section 404 is that last year it got gutted. So in a case called Sackett versus United States, the United States Supreme Court drastically reduced the reach of the Clean Water Act. And that has particularly pronounced effects on Section 404. And what that means is the statistics I'm going to show you going forward are going to greatly overstate the effect of Section 4, the effect that Section 404 would have today and will have in the future. So first, let's start with some aggregate statistics. And there are two key points here. The first is that for projects that do require Section 404 permitting, about 97% take that more streamlined route of getting a general permit. The second key point is that permits hardly ever get denied. So people just saying, no, you can't build, that essentially does not happen. And I've cited one study here. I've also found the same thing in my own research, that permit denials are exceedingly rare. All right, so what about specifically for clean energy? So here we're back to David Adelman's paper, which is coming out later on this year, by the way. And here you can see that only about 2% of all the wind and solar projects that he looked at required any form of Clean Water Act Section 404 permitting. In other words, they weren't getting individual permits, they just weren't getting any permit at all. And so again, this suggests that Section 404 is really having very minor effects on a renewable energy build out. Okay, so maybe it's the Endangered Species Act. What about that? And certainly in California, we are accustomed to thinking of the Endangered Species Act as a relatively fearsome statute. We've had our experiences with spotted owls and Delta smelt and Chinook salmon to make us think that this is really a powerful law. So again, I'll start by explaining at a very basic level what the statute requires and then how it works and then what we know in terms of statistics. So the Endangered Species Act really has a couple of important substantive requirements. Section 7 prevents federal agencies from taking actions that are likely to jeopardize the continued existence of listed species or to adversely modify their critical habitat. Section 7 also requires a process known as consultation, where federal agencies work together to figure out whether jeopardy or adverse modification is going to occur. And then Section 9 of the statute prohibits takes of listed species, which means doing things like killing or harming or wounding them. And then both Section 7 and Section 9, and then also Section 10, create workarounds for the take prohibition. They create ways in which you can incidentally and lawfully take species. So, like the other statutes we're looking at, the Endangered Species Act has tiered compliance processes. And in general, projects that are likely or may adversely affect listed species and are federal have to go through formal consultations. But projects that are less likely to have or unlikely to have those effects or will have positive effects go through much more streamlined processes. And in practice, this sort of tiered process gets used a lot. So a couple key conclusions here. First off, multiple empirical studies of the Endangered Species Act, including one of my own that I've cited here at the bottom of the slide, have found that jeopardy and adverse modification findings are exceedingly rare, that projects hardly ever get rejected under the Endangered Species Act. But in my work, I also found that it was routine for projects to get modified as part of the Endangered Species Act compliance. So they would get adjusted to reduce their potential harms to species, but not get blocked. All right, so what about for renewable energy projects? And here again, we're back to David Adelman's statistics. And for wind, he found that only about 4.5% of the projects required some sort of take permitting under the Endangered Species Act, which is a pretty good indicator of a level of seriousness of compliance issues. And then for solar projects, it was less than 1%, about 0.5% of projects that required this form of compliance. And you might say again, okay, what about litigation? I hear everybody sues under the Endangered Species Act. Well, actually they don't. And so here, more statistics from the other David Adelman and Rob Glicksman paper, where they found that as small as the volume of litigation under NEPA was, the volume of litigation under the Endangered Species Act was significantly smaller. I found the same thing in the study that I cited a couple slides back. Really, the overwhelming majority of government actions that are subject to the ESA do not lead to lawsuits. Okay, so you might at this point be wondering, well, does environmental law do anything? Like, not only does it not seem to be having a ton of effect on renewable energy projects, is it having much effect on anything at all? And here the quick answer is yes, it does. And there are a couple of key ways. So the first is that, as I mentioned with the Endangered Species Act, these environmental laws are often leading to adjustments and modifications to projects, and then often to negotiations over those adjustments and modifications. So here's the general conceptual chart that I showed earlier. And basically what's happening routinely is that project proponents and regulators are essentially asking, okay, what can we change with this project to get it into a more streamlined track for compliance, or to get it out of needing to comply with this particular statute entirely? And often that's a negotiated discussion. At the bottom here, there's a cite to a recent paper of mine that explores this with the 3 statutes we're talking about here, as well as a whole bunch of others. and explains how central this sort of negotiated adjustment is to the implementation of environmental law. And then there's another interesting issue, which is avoidance. So these are the projects that never get built because somebody thinks, I'd rather not go through the process at all. And a couple key points about avoidance. The first is that this is really hard to measure. So those of us who do empirical studies of environmental law, this is something we struggle with, trying to figure out what the extent of avoidance is. We know it occurs because there's plenty of anecdotal stories and it's complete common sense to expect that it does. We don't know how much. The other key thing to understand about avoidance is that it can be good or it can be bad or it can be somewhere in between. And I'll give a couple of examples here. So if a solar developer puts a solar farm on fallowed farmland rather than on some relatively sensitive and unimpacted habitat area, we would probably say that's a good thing. That's environmental law working as it should by directing people to put projects in better places. Same thing with the developer who puts a wind farm outside of important wildlife migration corridor. But then there's also the bad avoidance, where we basically have a good project that wouldn't have a whole lot of impact. But the project proponent says, it's just not worth it. It's just way too complicated. Even though I know this is a good project and I'm sure it would benefit the public, I can't go through the process. And again, we have some suggestions, I think, about how much each of these things is occurring. Bad avoidance is less likely where streamlined compliance processes are an option. And we've seen already that they definitely are with most wind and solar projects. But still, we don't have great data on the relative balance of these two types of avoidance. So last thing on federal environmental law. If NEPA or wetlands permitting or the ESA isn't really the problem, why aren't we building more of this stuff? Why aren't we making more progress? And to answer that question, it's helpful to think about what we need in order to build renewable energy infrastructure. We need environmental permitting sometimes, and we've been talking about that. But in addition, we also need motivated builders, we need interconnections to the grid, and we need local land use authorizations. And each of these things is potentially a big problem, perhaps a much bigger one than environmental law. So let's start with the motivated builders. Obviously, we do have a lot of people out there who want to build wind and solar farms, but our general carbon pricing policy has been a bit of a mess in this country. We haven't had a carbon tax, we haven't had a cap and trade system, we haven't signed something that would put wind and solar on more of a level playing field with fossil fuel energy. We have had subsidies for wind and solar, but until recently, they haven't been enormous, and they've also fluctuated tremendously, which is really hard when you're trying to build an infrastructure project that's supposed to produce economic returns over a very long span of time. The Inflation Reduction Act has changed that to some extent. It's a big step in the right direction. We still have problems with motivations sometimes to build wind and solar. Another huge issue is that you're not going to want to build a wind or solar facility if you can't connect it to the grid. And here we have huge problems. The basic issue is that in this country, we have largely privatized decisions about where transmission lines get built. Those decisions are generally made by private utilities or by regional transmission organizations that are largely dominated by private utilities. A lot of those private utilities have their own fossil fuel-fired power generation, natural gas or coal. They want to keep it online. They would much rather buy, sometimes from their own sources. So there's a real big problem, which the article cited here discusses, with utilities being unwilling or to build infrastructure in places that would help us bring wind and solar to the grid, or even actively resistant to that sort of construction. Again, this article is a good source for that. Josh Macy, who's cited here, is a professor at Yale, has written several other good things about this basic issue. Connecting to the grid is also really tricky for other reasons. There are huge backlogs that are taking a long time to work through. And then there's also local opposition. And this is a growing phenomenon. And it's opposition to wind, it's opposition to solar, it's also opposition to transmission lines. And this series of slides, by the way, comes from Shannon Rosler, who's a professor at the University of Iowa. And these animations here give you, actually, it's going to take me a second to get this going. Give you a sense. So this first one is showing counties that have developed restrictions on wind, sometimes outright bans. And then if we go to the next slide, you can see the same thing for solar power. And I wouldn't trust all of these pixels. I'm not sure Alameda County actually belongs on this chart, but the basic point here is that there is substantial and growing local opposition to building renewable energy infrastructure that is not being expressed through federal environmental law. And why is that? Well, there are a number of reasons. Some of it is about astroturfing, some of it is about misleading information, but a lot of it is about people basically feeling like they don't want their landscapes, what they feel like is their home, to be industrialized for the benefit of faraway companies in ways where they don't feel like they're necessarily seeing a direct benefit. And so there's a lot of debate about what we do about this. Do we preempt? Do we try to work with local communities? Do we do some combination of both? But in any event, I think most people who follow renewable energy closely think that this is a much bigger challenge than the challenges of, say, the National Environmental Policy Act. So last point on federal environmental law is that I've made the case, I think, that while there are data gaps, there are things we don't know, the extent of impact of federal environmental law on renewable energy infrastructure build-out is much, much less than popular media accounts and some academic accounts would suggest. But I think there are areas where we are facing and will continue to face real and significant challenges. And generally, that's likely to happen first where we have projects with major and controversial environmental impacts, and second, where we're doing stuff that's new. And perhaps the most important and prominent example of this is going to be offshore wind. So if you think back to the wind maps I showed you earlier, there is tremendous energy potential in offshore wind. And a lot of that energy potential is relatively close to areas of major energy consumption, which makes it potentially very convenient. But offshore is relatively new to the United States. It impacts areas where people recreate, where you have cargo ships moving, where you have fishermen who are active, where you have right whales and other endangered species migrating up and down the coasts. And so I think most people who work on these issues feel like these conflicts are potentially navigable, but you're not going to get an offshore wind project sited through highly streamlined forms of environmental permitting. It's going to require a more intensive effort. So what do we do in situations like offshore wind or other situations where the challenges are more substantial? Well, fortunately, there's a whole long list of potential options, and I'll just run through them quickly. We can make sure reviewing agencies are adequately funded so they can actually process applications and prepare environmental documents. We can maintain these systems of tiered environmental review that we already have and that are already important to our system, and we can refine them by doing things like clarifying the thresholds for obtaining expedited review. We can make sure mitigation measures are genuine. We can try to identify locations that are particularly promising for renewable energy projects and then create expedited permitting processes for those locations. Excuse me. We can provide extra governmental support for the review of pioneering projects. And then the most important point here with this list of recommendations is that there is not a new idea in this list. All of the things that I have listed here have been serious or major priorities for the Biden administration. They were priorities for the Obama administration. They are things that state and local governments have also done. So these are not new ideas. These are things we have long histories of doing and often doing successfully. Okay, so now let's turn to California and let's turn to CEQA and housing, which is the other big area of recent controversy that we've been hearing a lot about in this state. And here again, I'm going to start with motivations. And as with federal energy infrastructure, there are good motivations for people to be concerned about the processes that we go through to authorize housing. We have a massive housing deficit in California, and the economic impacts of that are really stark. So here you can see income levels of different types of people who are essential to our economy compared to the prices to afford even the most basic levels of housing. And it's a huge mismatch. So this is a massive problem. It is also a racial equity problem because the burdens of this fall most heavily on people of color. So it's a real big issue. And it's an issue that arises to a large extent because we just haven't been building enough housing. And particularly, we haven't been building enough housing in urban areas where it's close to jobs, close to the places where people want to work. And so here you can see a long-term chart showing housing construction in California. And we've consistently, for years and years, been well below what we would need to sustain to sustain an affordable housing market. Okay, so what does CEQA have to do with this? Well, CEQA is like NEPA. It requires the preparation of environmental impact reports, same concept, different terminology, when state and local governments take discretionary actions with potentially significant environmental impacts. It is different from NEPA in that it also has a substantive requirement. It requires government agencies to avoid or mitigate significant impacts if it's feasible to do so. And then here's the catch, or the connection. CEQA applies to discretionary government approvals of private projects, and that, of course, includes housing projects. So most housing development is at least some way subject to CEQA. So with CEQA, as with all of the federal statutes, we also have tiered compliance processes, and this is an important piece of the story to understand. So projects with lower levels of impact, can get approved through alternative compliance methods that do not require quite as much of a process. So things like an initial study and a negative declaration, or even more streamlined, a categorical exemption. All right, so let's talk about the controversy. So there have been frustrations with CEQA for many, many years. But the focus on CEQA and housing really ramped up a couple of years ago in 2015, when attorneys at Holland & Knight, which is a law firm based here in San Francisco that focuses on representing developers, published a report called In the Name of the Environment. And what the authors of the report did is to gather data on CEQA litigation to look to see what sorts of projects were being challenged and where those projects were. And they came to a couple of key findings. So first, they found that a lot of the projects that were being challenged, about 3/4 by their statistics, were what they called infill development. So that is development within existing urban areas. And this matters because infill development is generally the most environmentally friendly form of development because it has less impacts, both in terms of people driving, but also in terms of impacting undeveloped areas. And it also is very economically efficient to put people closer together. So this is potentially a real problem if CEQA is getting in the way of infill development. And then they also looked at what types of infill development were being challenged. And on the left side, you can see one of their charts showing that about 25% of the litigation challenges were to residential development. And then within that pool of residential development, they found that almost half of the challenges were to multifamily development. So again, you can see the problem here. If much of CEQA litigation, if there's a lot of CEQA litigation, and it is particularly targeted at multifamily infill housing, then we're really getting in the way, not just of equity, but also at building in the best, most environmentally sensitive places and the most environmentally desirable ways. Okay, this of course led to other studies, and the other studies have raised some questions about the Holland & Knight study statistics. So one of the most prominent is this study from the Rose Foundation. And I've got a lot of text here, sorry about that, but this summarizes some of the key findings here. So first off, the Rose Foundation study found that the vast majority of projects that go through a CEQA compliance process, most of those projects are not litigated. And in fact, the litigation rate is about 2%. Second, they found that only about 25% of the litigation challenged new housing units. They found by using a different definition of infill, and a definition that I think is somewhat more accurate because it looks to whether the area is actually surrounded by other development, they found that most of the challenges were actually to projects which would be greenfield, in other words, would be in previously undeveloped areas. And they also found that the challenges were to about 10% of the state's permitted housing. So the general case that the Rose Foundation made based on these numbers is that really the impacts of CEQA and CEQA litigation, more specifically on housing, were pretty heavily overstated. Now, this can sound like two very different views and people, perhaps telling totally different stories. But I want to just point to a couple things that I think are actually consistent in these studies. One is the finding that about 1/4 of the CEQA cases are challenging housing. That's a pretty big number, I think. the Rose Foundation puts the word only in front of that number. I don't think only fits in that situation. That is actually a pretty large number. And then the other thing that the Rose Foundation found here is that about 10% of the state's housing was actually challenged under CEQA. Again, I think that's a very large number, especially when you compare it to the numbers for federal renewable projects, which might be 1 or even 2 orders of magnitude smaller. So to me, this suggests that while the Hernandez et al. Study may have really overstated the extent of the impacts, it is actually on to something, that there is a real issue here. Okay, so what about before litigation? And this is important, obviously, because the vast majority of projects, regardless of whose statistics you look at, don't get litigated. So the process they go through beforehand really matters. And there have been a couple of good studies that have given us a sense, at least in general, of how these processes work. So the first is a study from the California Association of Environmental Professionals. This was done a couple of years ago, and the basic conclusion that they came to is that most projects were going through some streamlined form of CEQA review. In other words, they were not getting full-blown, full environmental impact reports. Those instead were generally getting reserved for the biggest and largest projects. Another study by Eric Bieber, who's a professor at Berkeley, and a couple of colleagues of his, also looked at local entitlement processes. They started with a relatively small number of cities, and they've since expanded it out. And the story that they tell is similar, although with a few additional twists. So first, they found that cities were by and large using discretionary review to decide when housing could be built. They also found, consistent with the Association of Environmental Professionals study, that a lot of CEQA streamlined review is happening. The effectiveness of that review in terms of shortening times they found varied from city to city. And then one of their most important conclusions was that it's really important to look not just at the CEQA process, but at the base zoning in the city, because that determines where housing can be built without discretionary review. And if you don't have discretionary review, you don't have a CEQA process. And just to give an example, I'll use the zoning map from my city where I live. This is Albany, California. And the pale yellow here is areas that are zoned single-family residential. And setting aside for a moment a few recent legislative changes from the state, what this means is that in most of the city of Albany, for many years, if you wanted to build a multifamily housing project, you had to go through a discretionary review process. You could just be denied. And even if the city wanted to grant your application, it had to go through CEQA. And so the Bieber study basically says that really matters. That's important to think about where these zoning restrictions allow us to build and where they don't. One last important thing to keep in mind with CEQA is that, as with federal environmental laws, avoidance matters. We know that it happens. It's hard to go beyond anecdotal evidence to get a good sense of where it happens or how it happens. And we also know, again, that it can be good, or it can be bad, or it can be somewhere in between. So a couple of examples here. CEQA provides pretty strong incentives to developers to use water efficiently and to design homes that will use water efficiently, because that can lead to an easier path through the CEQA compliance process. I would say that's a good incentive. That's one that the state should very much want to encourage. And similarly, if CEQA encourages people to avoid greenfield development and to build infill, well, that would be really powerful. We would want that because we would want somebody avoiding the impacts of greenfield development. On the other hand, you can think of a lot of potentially problematic examples, like a developer stays away from the wealthy neighborhood and instead builds in the poor area or the area where more people of color live because the CEQA process is going to be easier there. Or a developer who is pursuing a greenfield project starts out with higher density and then reduces it to minimize the local level of impacts. Again, that may be good locally, but that's not good for meeting statewide housing goals. So again, the key point is this happens, but it's hard to know where it's happening more and which set of incentives is more powerful. A couple final key points about CEQA. The first is that the landscape has changed dramatically in recent years. The legislature, as you can see from the press release on the left, has signed lots and lots of bills into law that are designed to affect housing and to affect CEQA processes. The report on the right summarizes some of that. I'm just going to talk about it in very broad strokes. But the basic concept to a lot of these bills is that if a project meets some set of statutory criteria, including things like being infill, being close to transportation corridors, meeting affordable housing targets, providing a living wage to construction workers, then that project can go through the process with either no CEQA review, or at least with a highly expedited form, or at least a moderately expedited form of CEQA review. So lots and lots of bills have built on this basic concept. Could we do more? Well, one recent argument that you can see here in this forthcoming article by Eric Bieber, Chris Elmendorf, Nicholas Morantz, and Moira O'Neill, is that maybe we should establish a presumption that there is no CEQA review for infill housing, and then require anybody who wants to have CEQA review for that housing to rebut that presumption by demonstrating that there would, in fact, be a significant impact. Another similar proposal comes from the Little Hoover Commission, which just recently put out this report. The Little Hoover Commission, first off said, we've already enacted a lot of legislative reform. We should see how it all works. But it added in this suggestion, which is a big one, which is saying that the state should exempt all infill housing from CEQA review. So we're almost done here. We're almost to the Q&A. But let me sum up a little bit on CEQA and housing, and I'm going to explain a few other things that I think should also be a focus. So the key points here on CEQA and housing. First off, most housing goes through expedited or no CEQA review. But EIRs are more common for housing than EISs are for, say, renewable energy projects. We do go through the more intense process more often here in California. Most housing is not subject to CEQA litigation, again, but the litigation rates are much higher than what we see under federal environmental law. Recent legislation has expanded, I say dramatically expanded, opportunities for building housing with either no CEQA review or with expedited review. And housing developers can routinely take steps to avoid or simplify CEQA processes, and that can be a good thing or a bad thing. And then the last thing is that more legislation is certainly possible, perhaps even likely. So we're not done with our work with CEQA and housing here. The last point I want to make here is that I think that if the debate is all about CEQA, we're missing a lot of the point. CEQA makes a nice scapegoat. You know, if you live in a suburban neighborhood with single-family residential zoning, it's very easy to say, oh, it's all about CEQA, and it's not about the zoning that I am so attached to in my own neighborhood. But the reality is there's a lot of other things that affect the willingness of developers or the ability of developers to build housing and other people to build housing. And a lot of it is not directly connected to CEQA. And some of that local opposition, that can be expressed in a lot of different ways, even if CEQA is changed. So while I do think, and I think most people believe CEQA is a part of the story, it is a mistake, I think, to view it as the central actor in this drama. So broader lessons, and I'm going to wrap up here and then take questions. First is, when you hear these debates about the role of environmental laws in getting in the way of things we need to build, I think be skeptical of simple explanations that blame environmental laws for getting in the way of building stuff. With limited exceptions, the data we have either don't support those claims or don't support at least the claim that environmental law is really a significant and major factor. Second, I think it's important to be aware that federal and state leaders have been working on these issues where they do arise for years. They've done a lot of sensible things, some of which have provided substantial, probably hard to measure, but still substantial public benefits. Third is that the challenges of environmental permitting, despite all the efforts we put in, they'll never go away. And it's always important for us to be looking for ways to do better. And relatedly, I think it's important to remember that good environmental permitting really requires a commitment to good governance, because it means, when it's done well, listening to and balancing different interests, often conflicting interests, different points of view. And so sometimes the reason it is slow to build stuff is just because it's hard to come to some sort of reasonable agreement or consensus, or to figure out what we should be doing, not because our laws are badly designed or because government is lazy or for some other reason like that. So with that, I will wrap it up, and I'm happy to take your questions.
Oh, thank you so much. Thank you so much, Professor Owen, for your awesome talk. And I'm sure that there's many questions circulating out and about. The first one we have is, why wouldn't the focus B, to require solar for all new housing to force the use and cut transmission line dependence on a federal level?
So the answer to that is that there are huge economies of scale in building utility scale solar, even when you factor in the cost of transmission lines. And so trying to solve our energy problems exclusively or even primarily through rooftop solar at a residential level, it's not going to work. We're not going to get enough solar fast enough. And it's going to be very expensive. And the way in which we have paid for that so far is to have people who get rooftop solar essentially be subsidized by the rest of the ratepayers. That can be kind of regressive because people who are poor, even though they use less energy, spend more of the wealth that they have on energy. And so the fear is that if we push too hard on rooftop solar, that we're really creating that it's not an equitable way to resolve our energy problems, and that what probably is far more equitable is to do more building at utility scale or at intermediate scales, like warehouse, parking lot type stuff. And then also, and this is another piece of it, to also emphasize having more and more energy storage so that we can balance the huge amounts of solar that in this state we're already generating in the middle of the day with the periods of peak need, which come later on. So I think that the quick answer is that's an expensive and very incomplete way to solve the problem.
Great. Thank you so much for the answer. Okay, our next question is, what do you feel about using low VMT areas as zoning approach to infill?
About using low VMT areas as, so, and I think, in other words, the question is, if we were to, as we're trying to define what counts as infill, which is key to figuring out where we want to encourage development. I'm going to kind of repeat the question to make sure I'm understanding it. If we could identify areas where people who move there are likely to not have to drive very far, does it make sense to treat those areas as infill, perhaps even if they aren't currently developed? I think it does. I mean, I think one goal, it's an important goal of developing infill, is to put people closer to jobs. And that's partly an economic issue. It's partly an environmental issue because then they'll drive less. It's partly just a quality of life issue because then they have more time to spend with their kids. But for a whole bunch of reasons, it's not an issue I've delved into in great depth, but I think a low VMT area, yes, that should be a very good candidate for development. And so a definition of infill that encompasses that sort of area does make sense.
Great, thank you. That was a great question. Okay, our next question is, how do you see the attacks on the Coastal Act as it relates to CEQA? Cal legislature keeps trying to find carve-outs to exempt certain areas from the CZCA.
So the most recent legislative session, there was a bill that did not exempt areas from the Coastal Zone Management Act, but that essentially tried to extend preferences for affordable housing that had been created in other parts of the state, and that basically allowed affordable housing to be approved on expedited processes, tried to extend those to the coastal area. So I think the first point is that I'm going to disagree with the premise of the question. I don't think that's eliminating or getting rid of the Coastal Act in a particular area. It is simply trying to make a modest adjustment to make it easier to have some affordable housing or more affordable housing in close proximity to the coast. And I think that's an important goal. I mean, I think Half Moon Bay is sort of a case study of both how badly better housing is needed in some coastal areas, and how it's really very much an equity issue. Like, the coast is, in California, like the coast, the beach is a place where we can get to it, everybody can go to. Like, beaches are free. You don't have to be rich to go to a beach, or at least that's how it should be. But if poor people can't live near the coast, then beaches become a whole lot more exclusive. And so there may be other bills that the questioner is thinking of that I'm not familiar with. But the ones that I am familiar with I think are actually pursuing a worthwhile goal of trying to create more affordable housing in an area where it tends to be incredibly scarce.
Thank you. That was a great answer. That was a good question. It's a timely question. And I think that would be a really positive thing to do. So, okay, our next question. What permit reforms would you recommend that California adopt, if any?
So I'll start with, so I ended the talk by showing a couple recommendations for either eliminating or limiting CEQA for infill housing. And I like the Bieber papers recommendation. I think that's a good one. It's not getting rid of it completely, but instead saying the presumption is that we don't do CEQA for infill housing. And that, I think that has, often when you flip a presumption, outcomes change a lot. You'd want to see if it actually works. It could be that municipalities that are hostile to infill zoning just continue to do massive CEQA processes for any sort of housing anytime and just override that. And if that happened, you need a bigger reform. But let me step back a bit and say that I think that's a sensible idea, but I think permitting reform isn't the biggest issue. I think the biggest issue is zoning. And so the more that the state can push, and the state's working hard at this already, the more that the state can push communities to rezone areas to allow multifamily housing, over the long run, I think that is going to make probably much more of a difference in our ability to produce housing than CEQA reforms. So, you could do both. They don't have to be mutually exclusive, and they do connect to each other, because if you make multifamily zoning eligible for ministerial approvals where there's no discretion as long as you meet the criteria, then you also don't have a CEQA process. But I'm convinced, this is the main point of the Getting It Right study. And I think those authors are right. I think the base zoning is really the most important thing. And again, I think some credit is due to the California legislature here, because it has been passing bills that do things like allow ADUs, accessory dwelling units, as of right, or that allow multi-unit development on many parcels, again, as a matter of right. I think those reforms are going to take a long time to pay off. They're not the kinds of things that transform the landscape overnight, but nothing does. But I think they're promising in the long run.
Great. Thank you so much for that answer. Okay, lots of questions. So have you done or are you aware of any studies on the effect of RCRA and or California hazardous waste law on developments and housing?
That's a good question. So let me take it in two parts. I'm not aware of any studies of RCRA, which is the Resource Conservation and Recovery Act. It's a federal statute that governs hazardous waste management. On housing development, I would be surprised if there are significant effects, because RCRA is mostly about current management of hazardous waste. I think what the questioner is probably more interested in actually is CERCLA, the Comprehensive Environmental Response Compensation and Liability Act, which we call Superfund, which is about contamination of older sites. And then how California hazardous waste laws play a similar role. And the basic issue here that I think the questioner is getting at is that sometimes it's hard to build on areas because they're contaminated. And, of course, they might be desirable. Bayview Hunters Point is a great example of this. It might be a really desirable location to have housing, but if there's contamination there, it's expensive to clean up. There are questions about whether it's being cleaned up safely, how safe is safe enough. So there are difficult challenges. With that said, I haven't seen an empirical study on the extent of those challenges. I am guessing it is not huge, and this is just based on my long ago background as an environmental consultant working on hazardous waste sites. They're not as plentiful as you might think. Like, you look on a map, you'll see lots and lots of them, but most of the developable area, even in a relatively old and industrialized city, is not going to have significant contamination issues. So I suspect that the scale of whatever problems arise is going to be relatively small.
Okay, great. Thank you so much. Next question. What has your research shown about the impact of CEQA on delivering transit, bus, rail, and bike projects, both in terms of budget and timelines?
So two things here. First off, the research on CEQA that I've discussed here is other people's research. So I want to give them the credit. I have done one project that was looking at the role of the environmental consulting industry in implementing CEQA, but what I've been trying to bring out is the research done by other people. The research that I have read and am familiar with is focused on housing. And the exception, I think, the Jennifer Hernandez study that I cited, that does also talk about transit. And she argues that there have been a lot of challenges to transit projects. I know there's been some pushback against those claims with people saying, well, wait a second, I think you're defining transit too broadly also. So I know that that is the debate, but I'm not in a position to comment on it in any depth. I don't know it well enough.
Okay, fair enough. Thank you. Okay, some of the questions. First of all, I wanted to tell you that we've had several requests for your slide deck. So several requests for the research and articles that you've shared in your presentation. So maybe we could work that out with you at some point to share some of
Yes,
that.
of course.
Yeah, okay. So if we need more, this is another coastal question. If we need more affordable housing in the coastal zone, which we definitely do, why not give back to the CCC the authority that it once had before the legislature took it away in 1981 to require it?
Well, it's really hard. So I'm not familiar with the exact terms of that older legislation. So I may miss the point here, but I'll try to answer the question. I think if the way it worked was to try to require private landowners to build things, well, we can't really do that. Like, our legal system doesn't allow us to mandate that private landowners build housing on their land. We can say, as a condition of getting an approval to build housing, you've got to build some affordable housing, like that kind of thing works. But we can't just say, you must build. If the way it worked was to say to coastal communities, as part of your coastal planning, you have to provide for affordable housing, we already kind of accomplished, or we're trying to accomplish that through state law, through the Housing Accountability Act, which requires local governments to actually have plans to provide for their share of affordable housing. And that was sort of a dead letter for many years. The Newsom administration has really stepped up enforcement and implementation of that statute with the backing of the legislature. So that we're potentially getting at through a different law.
Okay, great. Thank you. Next question. Could you please speak a little bit more on EJ and what extent the requirements set by AB 2108 may be impacting infrastructure development works?
Okay. So let me start by saying, so environmental justice, for probably most of you listening to the talk know what the concept means, but there might be a few of you who are newer to the idea. So let me just briefly explain what the concept is, and then I'll talk not so much about the specific bill, but more generally about intersections between environmental justice and housing production. So environmental justice is basically the idea that the burdens and benefits of environmental regulation and also environmental pollution should be equitably distributed. And it's also that this idea arose out of a recognition that that's often not the way things work, that people of color tend to be disproportionately burdened by both environmental burdens and then also sometimes by the fixes that we try to implement. So with housing, there's a complicated set of relationships, because for some environmental justice advocates, a big concern is gentrification. And their worry is that if housing development comes into their area, that development is going to spur more demand, it's going to spur increases in pricing, and it's going to drive people out. For other EJ advocates, or sometimes the same advocates in different situations, the concern is really more neglect. Like they want stuff to come and be built in their neighborhoods to be revitalizing the economy of the neighborhood. And then I think there's probably a lot of EJ advocates who would say, look, housing isn't really, we're concerned, we need housing, but we're far more concerned right now about air quality pollution in the Central Valley, or drinking water access, or warehouses. And so that's really where our focus is right now. And then there's also an interesting debate with CEQA, where you have some people who are saying, look, the effect of CEQA is really to empower, white, suburban, relatively wealthy groups, or white, urban, and relatively wealthy groups to oppose development and push it to other places. And so CEQA itself is an environmental justice problem. I have never heard any representative of an environmental justice group say that. Instead, what I've consistently heard from them is they say, this is our most powerful tool. We love this, I mean, not love this law, but this law is incredibly important to us because it gives us real leverage in situations where we otherwise would not have it. So, long answer, but I think the answer is it's a complicated relationship. There are multiple facets to the relationship. And that I think for a lot of EJ advocates, housing, the need for housing obviously is a huge issue for the communities they work with, but the CEQA housing conflict isn't really priority number one. There are other issues that they see as a higher priority.
Okay, great. Thank you. It's a very important topic. So we're going to move back to a question about utilities. Question for the presenter. Can you please elaborate on the incentives that electric utility companies have to get in the way of new generation and transmission? You hinted at the incentive to source for their own generation facilities, but what else is involved with the utilities protecting their vested interests?
Okay, so I'll try to explain it. I'll try to make it a little bit more concrete. So imagine that you are a major utility in the southeastern United States, and you traditionally got most of your power from coal. And in recent years, you've switched to getting a lot of that power from natural gas. And much of it is coming from natural gas facilities that you constructed. You're a vertically integrated utility, so you operate your own generation facilities. If you buy, and the other key thing to be aware of is that most likely it would be cheaper at this point for you to buy wind power from the Midwest or solar power from the Southwest than it would be for you to buy from your own natural gas facilities. But you've got a weird business model because you're a utility where you basically get to go to state regulators and say, here's what it costs to provide us power. So let us charge our consumers enough to cover those costs with, say, a 10% profit. And the utility says, okay. If that's your business model, you actually have an incentive to spend more on acquiring power, especially if you're acquiring it from yourself, and otherwise that asset might not be useful, it might be stranded. Even though it's going to cost your consumers more money, because you can pass the cost through to those consumers. That's sort of a simplified version of it. There are more elements to the story. There are other incentives that really build on this initial incentive. And again, Josh Macy, who's the guy at Yale, he's done really wonderful work on dissecting and these utility incentives. But that's the basic story. And of course, if you don't want that competition from cheap Midwestern wind or cheap Southwestern solar, one way to ensure that that competition doesn't really affect you is to make sure that there are bottlenecks and that power can't really efficiently get to you across the grid. And then you can go to state regulators who are like, well, why are you buying, why are you spending so much on your own stuff and you get it cheaper elsewhere? And say, well, we can't. We'll have blackouts if we try to get it from there because the transmission's not there. And so that's the basic dynamic that we see playing out and I don't think it's as much of a California issue. It's a bigger issue in other parts of the country. But under federal law, that's, we're concerned with the whole country. So that's the basic situation.
Thank you so much. That was very thorough. There's another question about, at the beginning of the talk, you mentioned that hazardous waste sites are not being created at the rate they once were. And they were wondering if you have data that you can share on this point.
I'm guessing somebody out there has data on this point. But I mean, I can tell you, before I went to law school, I worked as a consultant for a company that was doing hazardous waste site investigations and cleanups. And everybody in the industry, I think, was pretty well aware that that was a declining field. And it was a declining field because the combination of massive potential cleanup liability and then much stricter rules on day-to-day management of hazardous waste under the federal environmental laws of the 1970s meant that people just weren't dumping the waste out back or handing it to some shady contractor to take and put in the ground with the local pig farm. That kind of stuff just wasn't happening with anywhere near the frequency that it happened in the 30s, 40s, 50s, 60s, 70s, even kind of into the early 80s. So compliance practices had gotten massively better. And that in turn means that waste sites just aren't generated at the same extent. We still do, stuff still happens. There are still accidental spills. And we still find sites that might have been sitting with one person owning them for the past 40 or 50 years. And so they've never changed hands. They've never been investigated. We still discover new problems. But the rate at which we do that is much, much lower. And I can't give you exact statistics, but I am 100% confident that that is true.
Okay, thank you. Thank you for sharing that. There's a lot of more questions, and we are sort of starting to run out of time. So I just want everybody to know that we can give Professor Owen a copy of the questions that are left if we can't get to your question tonight. And we're just really excited that you are so engaged. So there's a couple more questions that maybe you can take one more, depending on.
Sure.
Yeah, okay. This one's an interesting one. It involves startups. Do you find that CEQA, this back to CEQA, do you find that CEQA and environmental laws allow large companies, nonprofits, or those with the economic means to continue to develop while limiting those with the initial cost of studies and potential for litigation harm in small startups? So it's not an environmental justice, but it's like financially, how can you afford this kind of thing?
Yeah, that's a great question. So one of the studies I cited was a piece about negotiations in environmental law. And in doing that study, I was really interested in trying to find some way to test for really just the effect that the questioner is describing, which is a sort of advantage for big, sophisticated entities. They just know how these things are done, know how permitting processes work, know the unwritten rules of the game. And I never was able to come up with a way to actually test that. But in all the conversations I had with consultants, with lawyers, with regulators, they all agreed that there is some of that going on. That the complexity of environmental permitting processes and the extent to which they are sort of an insider's game definitely does make it harder for newer business entities, smaller business entities. Now, that said, those newer business entities, those smaller entities, they can hire experienced consultants, they can hire experienced lawyers, so they can compensate to some degree for those informational disadvantages. But the disadvantages, I think, are definitely real, and maybe explain some of the frustration you often hear from small businesses about environmental law. But it's really hard to get a handle on how much of a factor that is. I'd love to figure out a way to document it more rigorously. I just haven't done that yet.
Okay, great. Okay, there is one other one. Some of these are quite involved, but this is kind of a fun one, and I'm curious to see what you say. So do you see a role for AI in helping to speed up the procedure or helping us to determine what projects will help us achieve our future goals and therefore deserve streamlining? So it's an interesting, AI is everywhere right now. So
Yeah, so I just read a paper that's, I think, either just came out in Science or just about to come out in Science. It is about using AI to identify sites that have jurisdictional streams or wetlands. In other words, places where you would need to get permits from the Army Corps of Engineers. And I think that is an example of a potentially valuable use of AI. We increasingly have just kind of amazing landscape data on things like what kinds of vegetation are being grown in areas, what the soil moisture is, groundwater. There's a lot of environmental data that through basically satellite imaging that can be used to basically investigate a site without actually going there, or at least start your investigation before going there. And it could potentially be very useful to developers, regulated entities, urban planners, people who want to identify good places to build stuff. And so I think that's I think an example of an area where AI technologies could be really promising in helping us. Permitting is ultimately about resolving. It's about trying to find win-win solutions where places where we can build stuff we need that's important, where it won't do too much harm, or maybe even might be in some way good if we factor in compensatory mitigation and trade-offs. And I do think there are ways that AI technologies could potentially help us do that better.
thank you so much. That was a fun question. And I just want to and it's interesting. I mean, we're all at the library, the state library, we're talking about uses for AI. So this is an area I had not considered. So I think our time is up, and I'm so sorry for those questions that we didn't get to. But Professor Owen, you've been such a gracious speaker, and we're just so grateful to you. So I know that there's questions unanswered, and I promise you that we will get them to Professor Owen. And I am going to thank you, Professor Owen, and toss it back to Elena.
Thank you, and thanks to all of you who've come out and listened.
Hold on 1 second. For some reason, video is not showing up. Anyways, thank you again to Professor Owen for his wonderful presentation. Thank you, Mona, for monitoring our Q&A. And thank you all for attending. If you're ever in the area, please visit the State Library in person at 914 Capitol Mall in Sacramento, Monday through Friday, 9:30 to 4 p.m. Thank you all for attending, and have a great evening.